Now I'm thrilled to continue our 6th annual review with our Session 5 panel on cooperative agreements. Our panel includes Diz Lucario, who is a partner at Venable and assists government contractors in all aspects of doing business with the federal government. Jeremiah Centrella is a partner at Nichols Lew. Prior to joining Nichols Lew, Jeremiah was general counsel for Mercy Corps. Lorraine Campos is a partner and a member of the steering committee of Kroll and Mooring's Government Contracts Group. And last but certainly not least, Tom Mason. And Tom is Thompson Hine. Tom is the leader of Thompson Hine's Government Contracts Practice Group. With that, let me turn it over to Diz. May I ask you to kick off the session?
Thanks, Alan, and thank you everyone for having me. Thanks PubK Law for having me, and all the sponsors for making this possible, and my colleagues, my co-panelists joining. We actually have a pretty chock-full program here, so I'll be brief in my introductory remarks and dive right in. I intend to talk about, discuss some of the updates in uniform guidance that occurred this past year. Jeremiah will be talking about the PPP program and how that relates to nonprofits. Lorraine will be speaking about Section 889, which probably needs no introduction. And then Tom will round us out with a discussion on Bayh Dole, which also hopefully needs no introduction for the folks. But I'll kick us off with a more generalized topic. So as many of you may or may not know, hopefully if you're playing in the grant space, you are aware that August of last year, there were some much awaited updates to the uniform guidance. For those federal contractors participating, the uniform guidance is actually the FAR for grants and cooperative agreements, the totally different regulatory scheme found at 2 CFR Part 200. When that was promulgated back in 2013, they were supposed to be updating it at a minimum every 5 years. And obviously this was a little overdue. So it was much anticipated. And as Lorraine will get into, the date of August 13 should not be missed either, because it precipitated the implementation of Part B for contractors and Section 889 compliance overall for grant recipients, which she'll get into. So that August 13 date was pretty important for Section 889 purposes. And in fact, the majority of what I'm going to speak about today became effective in November of last year in 2020. So it's only a couple months in place, whereas, as everyone knows, Section 889 took effect in August. So we'll get into that a little bit more detail when Lorraine speaks. With respect, though, to everything else, it was a pretty lengthy amendment to the uniform guidance, but it doesn't look like the whole slide is, maybe that's just my screen. I apologize. Is that fitting on there? Okay. But they fell into 3 buckets. And the first bucket that I talk about here, at least on this slide, we're going to go through them in a different sort of order, but really focused on the idea of creating flexibility. And that was really what the uniform guidance was designed to do back when it was promulgated in 2013, was to get away from this hodgepodge of circulars that existed prior to the uniform guidance and allow for more subjectivity in the grant world. There were some very prescriptive regulations under those circulars, and now the focus really is performance and making sure that things are operating in the grant world as they should be, and not necessarily looking to check boxes, right? But being more performance-oriented focused as opposed to just checking boxes for compliance. So that flexibility is important, and that was one of the main or key themes we see in these changes. As I mentioned with Section 889, there also these changes reflect certain statutory requirements, and then there's inevitably, every time you have a rule, there are questions and issues and language choice, and so there were some clarifying changes as well. Next slide. So, you know, the changes they range all over the place, from minor to large scale changes. And so it's really important to, you know, if you're really entrenched in grants and cooperative agreements, for you to take a look at the changes yourself. But I'll go through several in this 10 minutes or so segment. The first that I want to talk about is exceptions. So uniform guidance did recognize the need for exceptions, to these to the guidance, but it really hadn't taken hold in my experience. It was very difficult to get exceptions, very difficult to convince an agency to deviate from the uniform guidance. And what they did in this is they tried to push agencies to be more comfortable. And now they have this language in here, strongly encourages federal awarding agencies to add or remove requirements by applying a risk-based, data-driven framework to alleviate select compliance requirements. So what does that mean? Well, really what it means is that in certain situations on a case-by-case basis, it may make sense to waive certain requirements under the uniform guidance to allow for more and better productivity of a grant program. Again, the whole idea of the uniform guidance, getting away from the circulars, was to create flexibility, to create a more performance-based assessment of grant and cooperative agreements. It's a big difference between a grant and a cooperative agreement and a contract is a contract has deliverables. A grant and cooperative agreement is meant to effectuate a public purpose. And that's not always measurable in deliverables and things like that, but rather assessing whether the program is successful or not. And sometimes the round peg and the square hole just don't work. And so this revision to section 102 is helpful because the idea being that you can go into an agency and say, look, we need to deviate from the terms of the uniform guidance for this reason. And this hopefully will give organizations an opportunity and the regulatory backing to say exceptions are acceptable. The problem is we're going against decades of the way of doing business, right? And not deviating from rules and regulations. And so you're trying to convince government actors to do something different and put themselves out there maybe a little bit. So it's going to take time to see how changes like this take hold. But I am hopeful that, over time, agencies and grants officers will feel more and more comfortable. Now, we'll have to also see how OIGs react to this, because inevitably an OIG kind of counteracts what agencies do sometimes to be more flexible. So that is definitely something we'll have to keep an eye on. Next slide. Kind of continuing it's a theme, though, of being performance oriented. They actually gave agencies greater strength or greater ability for them to terminate awards based upon not being able, or that when the goals or the priorities of the agency are not being met. Previously, termination for cause, there was always termination for convenience, but there was not really any language in there that allowed for something that, hey, we actually don't want to do this anymore. Now, they could do the termination for convenience, but that had different repercussions. So now agencies do, if they want to change course, and we saw some of that when we switched from an Obama to a Trump administration. We may see some of that switching from a Trump administration to a Biden administration, where agencies are changing priorities, and there may be grants out there or programs out there that are no longer a priority for the current administration. So we may see some of this new termination language actually put into effect in the coming months, based upon changes in priorities between administrations. One of the more notable changes also is this 414F about the de minimis rate. So it was much lauded that there was this de minimis rate, right? Indirect cost submissions and developing a negotiated indirect cost rate are an absolute pain in the butt. And lots of small organizations did not want to go through that process, the expense and the time of doing a NICRA. So they came up with this indirect rate, said, look, you can get a 10% indirect rate right out of the box. You don't have to submit anything to prove it. You get that 10%. And that often will help make up that gap. But there was a big exception to it. You could not be eligible for the 10% if you had previously had a NICRA, which took out a whole swath of companies who had gone through the effort of a NICRA, but maintaining that NICRA was so cost burdensome that they stopped doing it and they just let those costs go. They were actually ineligible. And I remember advocating on behalf of a number of clients that even though they didn't have a NICRA, they should still be eligible for the 10%. But the language in the uniform guidance didn't allow for that. Well, they've opened that back up. And so now those organizations who once had a NICRA but decided that it was too cumbersome, too difficult to maintain, they can simply get a 10% even though they had that NICRA before. That doesn't make them ineligible going forward. Next slide, please. One of the big reasons why you might not want a NICRA is there's a lot of important data in a NICRA. And under the uniform guidance, this was one of those issues that was a little open previously, but now there's a requirement that your indirect cost rate or your NICRA is actually going to be available publicly. And so that obviously is another big reason why organizations may not want to have a NICRA. They may not want to have that information out there publicly. And so something for organizations to consider. The other thing is that there was a lot of discussion 2 years or so into the Trump administration about the impact of authoritative guidance. In other words, agencies would often issue non-rules about how they were approaching their business, how they were approaching administration of regulations, of statutes. We saw it from the Justice Department. We saw a lot of different agencies had issued what they call non-authoritative guidance. The uniform guidance took a position that prohibits federal wording agencies from including references to this non-authoritative guidance. In other words, if it hasn't gone through a rulemaking, it really shouldn't be something that organizations are subject to. I'm moving quickly here because I want to be mindful of my colleagues' time. 322 on domestic preferences. This is, as of just yesterday, this is a hot issue again, and it will probably continue to be a hot issue as we go through a recession, a COVID recession here. But essentially encouraging grant recipients to maximize the use of goods and products in the United States. We'll probably see more development on that as we get into a Biden administration as well. Next slide. Another one, fortunately, the grant world tries to catch up to the contract world. 320 changed a lot of the thresholds for procurement, raising the micro purchase from 3,500 to 10,000, raising the simplified acquisition threshold from 150 to 250. So that obviously makes a big difference for organizations in terms of how they go about procuring with those higher thresholds, giving them much more flexibility as those thresholds are pushed up. And also the ability to request a micro purchase limit up to $50,000, which would be pretty significant. Closeout requirements, they extended the due dates on those from 90 to 120 days, which is also critical. Next slide. I mentioned Section 889, which Lorraine will get into here in a couple minutes. There's also some other statutory provisions included in the amendments, with probably most notably Part 183, never contracting with the enemy, and then some changes to executive comp as well as FAPIS. The executive comp is probably not as significant on the grant side as it is in the contracting side of the house, because many nonprofits are already subject to disclosing that information in their nonprofit reports. And next slide, please. So the one thing that I want to touch on before I turn it over to my co-panelist, Jeremiah, requirements for pass-through entities. So here there's also a recognition that a prime recipient of a grant or cooperative agreement does not necessarily have the obligation or authority to really impose certain requirements on subrecipients. There's this relationship, right? But there's always been, this tension with the federal government about privity of contract, right? What does the federal government want to get involved with subcontractors, right? For contracting colleagues, privity of contract is tightly held by the government. They don't want to get involved in prime sub disputes. And that's largely the case in the grant world, except when you have NICRAs, you have a third party agreement. You have another agreement out here between a cognizant agency and the subrecipient. So outside of the prime recipient subrecipient relationship, you have this subrecipient relationship with the cognizant agency. What these rules are saying is, look, you, prime recipient, don't have to get involved with disputes and issues relating to a subrecipient that deal with the organization more broadly. Certainly when it comes to a relationship between the prime and subrecipient over that particular program or that particular grant, the prime recipient is fully responsible. But when it comes to broader organizational issues, that is going to be between the cognizant agency and the subrecipient. And this actually gives prime recipients a lot of opportunity to step out of that uncomfortable situation where they have these organizational wide issues that might be coming out of a single award audit, that might be coming up through indirect rates. So this gave primes and subs a little bit better idea of how to navigate kind of the complex playing field. With that, I want to go ahead and turn it over to Jeremiah to take us away on the PPP program.
Thank you, Diz, and thanks to PubK and all of you. Appreciate the chance to talk about the payroll protection program, the infamous, very infamous loan program, first created under the CARES Act, and then more recently updated in the Economic Aid Act. Very quickly, I'm assuming most folks are familiar with this, but it's at its core under the CARES Act, 100% guarantee of $10 million forgivable loans that would be issued through financial institutions. And the SBA is the primary agency that administers the program with support from Treasury. For those of you who haven't been paying close attention, previously there were a host of, I think, about 21 different interim rules, FAQs, and other things that were trying to clarify what was a hastily rolled out program. Those have since been consolidated into 2 interim final rules, both issued on January 6th, that both address the PPP loan program under the CARES Act and what is now everyone's efforts to obtain forgiveness, and then what are called second draw loans under the Economic Aid Act in the second rule. Next slide, please. Yeah, so really, I think the takeaways are, one, clients should be looking at whether or not they're eligible for second draw loans. Those are up to $2 million, and applications are accepted through March of 2021. And for any client who was eligible for first draw loans, so up to 10 million under the CARES Act, and applied, but for whatever reason returned funds or reduced the amount that they claimed, there's an opportunity to also seek an increase in their first draw loans up to the amount that they would have been eligible for. There's a number of conditions around that, but something to consider, both second draw, which is a new loan, and the potential for increases for clients. Next slide, please. So the risks around the PPP program are interesting and somewhat unique, actually, in the fact that it's a loan program with very favorable interest rates. So if you're accessing capital in a crisis, you're looking for financing, this would be probably one of the best loans you could get, the 1% interest rate, a deferred repayment period, and in quite favorable terms, and then the potential for forgiveness as well. So there are sort of 2 components to risks associated with how you apply for and obtain eligibility and go about this. The first is, of course, that you're not eligible for loan forgiveness, and therefore you have to repay the loan. For most clients, that's not a terrible risk to take given the terms of financing. But the real risk here is False Claims Act liability, and making false representation certifications, providing false facts supporting your eligibility determination. And as it relates to U.S. government funding, grants and cooperative agreements, there's the risk of double dipping, charging both your awarding agency and the PPP loan program for the same costs. There's also, of course, potential for bank and wire fraud charges, given these are loan applications. Next slide, please. So I'm really focused on the issue of nonprofits. There are obviously plenty of additional issues that go along with for-profit companies, but there are unique aspects of nonprofits, and we're looking at this from that perspective because they're the most likely, in my view, to have be in a position where they've got extensive grants and need to address this interplay between the PPP program and grants and cooperative agreements. And there's some interesting things here. So in terms of eligibility for nonprofits, focused here on 501c3 operating charities that are eligible, would not ordinarily be eligible for SBA loan programs, but are specifically eligible. One of the issues that comes up, I think, a fair amount with clients, particularly in the international space, is the issue of consolidation or affiliation rules and eligibility. So when do you have to count the employees of all of the affiliates versus one nonprofit? And it's a unique aspect that's slightly more difficult, I would say, than dealing with affiliation rules when you're dealing with a for-profit. And I think the starting point there is looking at whether or not entities are consolidated, but there's a bit more to that. But one of the other issues, if you've got clients or others who have applied for and have received a loan and did so before May 5, before May 5, 2020, the SBA had created ambiguity, I would say, around whether or not foreign employees, whether of an affiliate or of the U.S. entity itself, counted towards the 500 employee eligibility requirement. And ultimately, they issued guidance, I think it was May 18, stating that they would not pursue remedies against an organization that used the 500 employee eligibility requirement based off of only employees with principal place of residence in the U.S. So that's interesting. I will say, being one of the folks who was deeply involved in those conversations with SBA, with Hill staffers and others around international non-governmental organizations, in my opinion, that initial ambiguity was not a mistake or oversight, and a number of INGOs found that critically important for their purposes. Next slide, please. So few other aspects of nonprofit eligibility. I think one of the clarifications in this new rule issued on January 26 is that hospitals that are controlled by state or local governments are eligible. Again, that's an exception to standard SBA loan eligibility rules, as long as they receive 50% or more of their funding from other sources, so other than the government entity that controls them. And then the religious institution exemption from the affiliation rules, I think, is interesting, and is how you've got some very, very large religious institutions receiving quite a lot of PPP loans when broken out across their various parishes or what have you, and a very broad exception to those affiliation rules, essentially. Next slide, please. So the important thing when you think about the second draw loan is that really all the same terms and conditions of the first draw apply, except for a few additional requirements. So the entities have to be smaller, 300 or fewer employees. They have to show a revenue reduction in 2020. So unlike the first draw where you didn't have to show actual impact, for the second draw loans you do. And they had to have received a first draw loan, and they had to have used it by the time the disbursement of the second draw loan. Next slide, please. So really important, I think, are the certifications. Obviously, if the key risk is False Claims Act liability, certifications that go along with the loan application and the forgiveness application are critical, quite important. a couple of those that I'm just going to focus on real quickly because I think they're most important. One is certification that you use the loan proceeds for eligible purposes. And that includes 60% of the loan proceeds for payroll costs and 40%, up to 40% for other eligible operating costs. One of the issues I think many clients deal with is, how do you sort of show that you're using those proceeds for those costs when cash is fungible? And I think there's a variety of ways that different entities are figuring out how to do that, and including separate accounts with very clear accounting practices to demonstrate that if necessary. But it is an interesting question as to how you can make that certification when cash is fungible. Next slide, please. The issue that's interesting in this new rule, there's a sentence that states quite clearly that costs of foreign payroll or costs of supporting foreign operations are not eligible. And I think there's a question yet to be resolved around what does it mean if the costs of supporting foreign operations are not eligible. Does that just mean you can't charge rent and other utilities and such for foreign offices, or does that mean that if you've got employees or others who are working in the U.S. but supporting foreign operations, there's an issue there? I think you can sort of look at the totality of the circumstances and argue that what that's really about is making clear that costs of foreign offices are not eligible, but employees working in the U.S. Supporting foreign operations might be eligible. But an interesting interpretation question, and a little lack of clarity there. I'm going to sort of move through some of this a little quicker, and recognizing you all have the slides, I don't want to eat too much into my colleagues' times, and I think there's fairly basic. So if we could go to the next slide, and we'll work our way towards really the specifics around the interplay with grant funding. So I will say that one of the most important certifications is, of course, the certification that the loan proceeds are necessary and to deal with the economic uncertainty under the circumstances. As I think many of you know, there is a safe harbor that if you receive a loan of less than $2 million, that certification is essentially deemed in good faith. But for loans over $2 million, all of those loans will be subject to review of whether that certification was made in good faith. We're seeing clients undergoing that review across the board, so it's certainly happening, and there are a number of SBA FAQs, including 3153, that deal with what they'll be reviewing for. Most importantly is a more recent loan necessity questionnaire, and there's a specific questionnaire for nonprofits that focuses on really the uncertainties that would have been placed at the time and afterwards, what the funds were used for. So it has a whole host of questions around endowments, restrictions on endowments, whether the organization is making capital investments after receiving the loan, those types of things. So don't have time to go into that in detail here, but quite important to understand what those questions are and how clients would be responding when they do get that review. And SBA in FAQ 53 has made clear that they'll look at the totality of the circumstances. They won't just base a determination on whether or not the loan was good faith or not on that questionnaire, but it is an important part. And so the other thing is that the consequences of them determining that the certification is not in good faith, really, if the organization immediately essentially pays back the loan, they said they won't seek additional remedies. So, somewhat limited risk there, but again, concerns around the False Claims Act. Next slide, please. One other thing to keep in mind is that under these new rules, entities have 10 months after the end of their chosen covered payroll period, which is again up to 24 weeks, to apply for forgiveness. And basically what happens at the end of that 10-month period is that payments need to start being made. So there's, for many entities that receive loans, they're still working through the forgiveness applications in that process now, and needing quite a bit of support as they deal with that issue. And then the other basic considerations is ensure that you're only including eligible costs during the covered payroll period, and that reductions in payroll headcount may impact the amount that can be claimed for forgiveness. And then critically, once again, don't double dip. So lots of guidance out there around this. I'm not going to get into it in much detail. Next slide, please. So when it comes to the interplay specifically with grants and cooperative agreements, there was much debate sort of towards the beginning of this, when there was ambiguity, no guidance being provided around, how did the PPP interact with federal funding. Since then, I think it's been really clarified that, and really in OMB in 2026, that no entity should be double dipping. That is, charging either directly or through indirect costs that they are also seeking forgiveness under a PPP loan to an awarding agency. So quite clear, no double dipping. Next slide, please. Still, I think quite a bit of questions that are coming up around this as organizations pursue loan forgiveness, and how to go about dealing with that situation. One of the critical questions is, should you charge your NICRA, for example, or should you seek forgiveness under your PPP loan? And really the closest thing there is to any type of guidance is in 2026, although it's not directly on point by any stretch, but it talks about the need to exhaust all the resources before accessing the flexibilities, the COVID flexibilities that OMB had created, allowing organizations to charge certain costs against an award while they were suffering the consequences of COVID shutdown. So suppose you could imply that means that organizations should seek forgiveness rather than charge those flexible costs directly to awards, but it's certainly not clear and directly on point, and I think doesn't need to be the direction in terms of what organizations should do, but it's something to be aware of, the interplay between that sentence and how you make the decision on where you charge costs. USAID, which have dealt with this quite a bit in the outset, interesting their guidance. Every attorney and accountant's favorite sentence in an FAQ: consult your accountants and your general counsel around this question, and really didn't provide any guidance. Next slide, please. So some interesting questions here, really around fixed obligation grants and de minimis indirect cost rates. Here, there's no identifiable sort of PPP eligible costs that are being charged to the award. So the question there is there any need to go further in addressing the potential for double dipping? And it would seem there's a good argument that there's no need to reduce either the fixed obligation grant amount or the de minimis indirect cost rate on the basis of PPP loan forgiveness, but certainly open to interpretation. And then as thinking about calculating the loan amount and the certification around necessity, and a number of questions come up around this, and whether or not, if you have federal funding, you can still claim that there was uncertainty and that the loan was still necessary. A number of articles about this back when the program was just getting started. Certainly, in my opinion, quite clearly, you can still claim necessity. And the reason you can do that is, of course, organizations are still experiencing significant shutdowns and really massive impacts on their federal funds and the ability to then generate indirect costs, creating uncertainty. Next slide, please. So again, to this point around seeking forgiveness versus charging the awarding agency, a couple of things to consider here. You've got to go one way or the other. It appears as though the decision is up to the entity. And when thinking about whether to seek forgiveness for direct chargeable costs or charge those to an award, I think the key consideration there goes back to that language in OMB 2026. And if you by charging those costs, so for example, the cost of team members who are sitting idle during a shutdown, by charging those costs to the award, if that means that you're no longer able to achieve the goals and the outcomes from that award, it might make a lot of sense to charge those costs to your PPP loan program, seek forgiveness for those, and be able to continue on with the award in the event that that amounts aren't increased. And I should note that, as far as I'm aware, no agency sort of made any blanket determinations that they would increase the obligated amounts based on the increase in costs associated with paying for team members while things are on shutdown. So that's an important consideration. And then the other around NICRA eligible costs, something to really keep in mind is, by seeking loan forgiveness, instead of charging costs to the NICRA rate, you're lowering the NICRA rate for that year. And the open question right now is what impact that would have on your future rate negotiations, if any. Really something for clients to consider as they approach the decision on whether to charge NICRA eligible costs or seek forgiveness. Next slide. I think that might be it, actually. Well, thank you again. And with that, I'm going to turn it over to Lorraine.
Great. Thank you, Jeremiah. Next slide, please. So I'm going to go pretty quickly so we can make sure that we stay within our time period. What Diz mentioned earlier, my co-panelists, is that under the uniform guidance that was issued in August 13th, 2020, there was an adoption of Section 889 for federal grant recipients. For those of you that may not be aware of 889, I wanted to provide a bit of background. So starting in 2011, the U.S.-China Economic and Security Commission issued a report describing vulnerabilities in the U.S., specifically related to communications infrastructure and products. Then in 2018, next slide, please, MITRE issued Delivered Uncompromised. If you want some good reading, I would suggest trying to pick that up. It's a report that makes recommendations on how the U.S. government and private sector can address growing threats like counterfeit parts that pass ordinary inspection but fail operationally, and malware that exploits latest latent vulnerabilities in firmware and software and threaten unintended or unexpected physical results. Next slide, please. So we had those two reports. Lots of issues that have come up related to vulnerability of our systems. So we then now have the NDAA. So the fiscal year 2019 NDAA requires federal government as of August 13th, 2019 to not procure, obtain, or extend or renew a contract to procure or obtain equipment, system, or services that use covered technical equipment in their systems. The big, I think, change this year is that the idea is, or I guess the big change this year is that Section B went into effect, and that went into effect August 13th, 2020 for federal government contractors from the federal government from entering into or extending or renewing contracts with any entity that uses any equipment. So Section A was providing it, Section B was using the equipment. So that was a big change in the government contract world. So next slide, please. So where we're getting to is what's considered covered telecommunications equipment, and that's Huawei and ZTE telecommunication equipment, but then also certain other video surveillance equipment and services from other companies that may be identified. Next slide, please. We also have within this Section 89B some new definitions of backhaul and interconnection arrangements and roaming. But unfortunately, we don't have as many definitions as we would like for use or system. So the language in the statute is very broad and requires significant interpretation from regulatory authorities to be implemented. So the definitions of use could imply the government would be prohibited from doing business with a government contractor that has an internet service provider that uses Huawei or ZTE equipment. We've also gotten lots of questions from clients regarding using of video surveillance equipment, and then questions of whether that is in fact used for the government contract for the government's purposes or from the entity's purposes. But next slide, please. The big kind of change, as Diz mentioned, was the OMB update. So the revision of 2 CFR Part 200, and that's Part 216 and 471 were revised to adopt for federal grants recipients the basic tenets of the Section 8889. And then the agencies administering the loan grants and subsidy programs were asked to prioritize funding by those recipients that transition away from covered equipment and replace it with alternative equipment. Next slide, please. So what were the changes? In 2 CFR 200-216 states that recipients and subrecipients are prohibited from obligating or expending funds to procure, obtain, extend, renew, contract, procure or obtain, or enter into any contract to procure or obtain equipment, services, subsystems that use these covered telecommunications equipment or services as a substantial or essential component of any system or critical technology as part of a system. And so what we've done, or what we see here, is the federal government has taken the requirements from 889 and apply it, to the most part, to grant recipients. Next slide, please. They also address telecommunications and video surveillance cost. So we have a new section, 200-471, and what it does is it provides that costs incurred for these telecommunications and video surveillance services and equipment, such as the phones and the internet, cloud servers are allowed except for the following circumstances. And then it refers back to the 200.16. Next slide, please. And then we also have a direction regarding indirect costs, and their prohibited equipment are excluded from those allowable cost pools. Next slide, please. So that's kind of at a high level. So the questions that have come up, which I think are pretty interesting, is that there's no flow down requirements, no representations or certification requirements for grant recipients, and no requirement for awardees to make affirmative certifications. So what does that mean? So what we have is a situation where, as a grant recipient, you have the requirement to ensure that that you're not including these telecommunications equipment as part of your grant funding and what you're providing to the government. But there's not that requirement to flow it down. I've advised clients that it's prudent, it's a good idea to ensure that your subrecipients are agreeing to these requirements. And so I've advised clients on that. But unlike the procurement regulations set forth in the FAR, there is no affirmative certification requirement. And so many clients and many companies, entities are thinking about best ways to ensure compliances, some best practices, and refund obligations as well. Next slide, please. As far as kind of an outline or thoughts on how to ensure compliance with these grant requirements, as we're talking about this, I've advised clients to think about a risk-based, compliance-based approach. And that is, if you're a grant recipient, taking a step back, thinking through, what are the grants that you're receiving, as well as hopefully you're already doing that in your contracts, but then also think about your grants, inventory and categorize your direct and indirect purchases under your grant, and start the process for written risk-based procedures for evaluation, solicit necessary or not necessary, but maybe as an entity, the requirement that you want to have for compliance, certifications or representations or something from your subgrantees. Also develop your processes to track your responses and educate your organization's professionals from purchasing, procurements, and materials management regarding these requirements, as they are not likely to go anywhere soon, and they're creating challenges for many of those in the industry. So I'm turning it over to Tom now to finish us off. Thank you.
Thanks very much. I'm going to talk a little bit about grants and cooperative agreements as they apply the Bayh-Dole Act. And the Bayh-Dole Act is formerly called the University and Small Business Patent Procedures Act of 1980, Public Law 96-517. The Bayh-Dole Act is codified 35 U.S.C. 200, and it's regulated at 37 CFR 401. It's been around for a long time, and it's changed a couple of years ago, and there's a new change that's in offing. I find that this area was pretty active during the pandemic so far. And quite frankly, the government's not in the business of manufacturing pharmaceuticals or medications. And so they're looking to universities and other companies that will take government money to do the laboring, to grab the laboring oar to develop things that we need, and certainly if we need it in the pandemic. And so the Bayh-Dole Act does apply to grants and cooperative agreements. And the difference between, in my opinion, a grant and a contract, I actually litigated the case in the late 1990s, and where I argued for the Justice Department that a grant wasn't a contract and lost at the Court of Claims. So it is a contract, and the difference is, in my judgment, is that the contractor writes the specs, the terms and conditions, and incorporates some statutes that are required, regulations and statutes that are required. Whereas in a contract, the government will publish its own specifications. And so this is pretty attractive to universities and also small businesses who are interested in taking government money and inventing formulas and other products where they can, at the end, use the government money and own the invention. Next slide, if you would, please. And so what we're trying to do is take a look just briefly at where the applications of Bayh-Dole are in the grant arena. We see them, I see them most often in SBIR and STTR circumstances. And generally speaking, this is really a good deal for a contractor, and it's also a better deal for the government. And so I don't have any citations to specific statutes. I've got more of a checklist here, and that can be followed. But what we're looking at here is just a general concept where a contractor, a grant recipient, a university is going to take government money, and they're going to do research with this government money. And the whole purpose of the Bayh-Dole Act is to let the contractor, let the university own the intellectual property. And one of the things that I see throughout all of the communications is that the government's very intent on having its money used for the purposes that were set forth in the grant instrument or the cooperative agreement or the CRADA or whatever instrument they're using. They want a government purpose to be satisfied. And so if the IP doesn't go to that government purpose, they're not going to be as receptive to letting the letting the contractor commercialize that IP. And so one of the things that we're going to talk about just briefly is government march-in rights. The government's willing to give money to a grant holder, and they're willing to support the grant holder in their development of intellectual property. But as soon as you stray from that government purpose, you run the risk of the government getting involved. I have personally never seen a case where the government marched in and said, we're taking over. I've seen hundreds of cases where the government has gotten a license on that IP and exploited it in a different way. And in particular, when it's going in a direction different than where the contractor is headed. Next slide, please. So subject inventions, these are defined by Dole as inventions conceived. This is where the idea is conceived and it's reduced to practice during the grant performance period. And it's Bayh Dole is triggered when funds are used in that IP generation. Next slide. I'm going to go fast, and you can pose questions later, or you'll see with the slides when you get them. But let's go to the next slide. So the implications of IP ownership, there's nothing in the US patent law that changes with Bayh Dole. You have to follow all the patent rules and all the rules of the USPTO. But the US is granted under the Bayh Dole Act a worldwide, non-exclusive, irrevocable paid-up license to use a subject invention. There's a caveat that I get involved with quite often where the United States wants manufacture, this dovetails with the last presenter, to be performed in the United States unless you can get an exception. I've been able to get exceptions from Edison and from NIST, and oftentimes it's more cost effective and more schedule efficient to do the work in the United States. The invention has to give the governments the right to march in, and the purpose of the grant must be fulfilled. These are the basic requirements of what you have to do in order to be an IP owner if you're a contractor and you're using government funds to conceive of your invention. Next slide. So one of the things that I want to just focus on briefly is the company has some responsibilities under the grant contract, not necessarily the Bayh Dole Act provisions, but under the contract, the grant provisions. The IP assignments must be obtained from all the employees. Employees have to assign their rights to the IP to the company. That's consistent with patent law. The subject invention by contract has to be must be disclosed to the patent administrator, and that in turn has to be disclosed to the agency so that we know that there's a patent that's being conceived. This is all done generally very confidentially without any public information. Next slide. It's the contractor's duty to spend the money and file for and get the patent, and then prosecute the patent, and then practice the patent. The contractor must give the government notice so the government can step in if the contractor decides that they don't wish to own the patent, or if they decide that they're going to abandon the project. Next slide. There's a utilization report of how the patent's used. There's an annual statement disclosing all subject inventions. There's a final statement when the grant contract ends, which summarizes the inventions. And I put a note here that contractors, grant holders, have to give the government at least 60 days notice if they elect not to file a patent. That gives the government a chance to step in and file for the patent in its rights. Next slide. What happens if you don't comply with Bayh Dole? Well, I'll tell you the big three are the last three. I've not seen loss of IP. I've seen restriction of IP. I've seen the government exercise march-in rights, not by saying marching in, but they'll use the license that they obtain to commercialize in a different area, and they may impose some further restrictions. But I've not seen them actually march in and take it over. But here are the big things, and this is where I'm going to close. If you don't follow the Bayh Dole Act and you're a university or a small business, you're going to put a cloud on the title to the subject of invention. And it comes up later on downstream when we're trying to get money from an investor, when we're trying to merge, where we're trying to commercialize a vaccine or something like that, where somebody will come in and challenge the right to do so. And so these are all back-end risks that we can avoid if we follow by Dole. The negative impact for investors and on the ultimate corporate transaction, I think, is something that we want to not pass by but consider. Final slide. And so I just wanted to point out two things here. It's imperative we remain compliant, corporate compliance, grant contract compliance. There's a lot of training involved, and we look to the government agencies to give us guidance. Used to be NIH, and now it's NIH through its iEdison portal and NIST. Commerce has delegated to NIST the authority to manage this. And NIST has issued, I'll just say this as my last comment, its intention to change the rules on March-in. They intend to limit the government's use of March-in rights where the government's simply trying to march in and gain an economic advantage. So that's it for what I had to say about the Bayh Dole Act.
Tom and all of the panel members, thank you very much for an outstanding presentation. You've squeezed an enormous amount of data information into a very short period of time, and we very much appreciate it.